Good afternoon, class. This is Criminal Evidence and Proof. This is your instructor, Adela Kowalski Garza. And today I'm going to present to you an assistant district attorney. Her name is Pattillo. She's been a lawyer for about 10 years. She was one of the youngest prosecutors that came to work here at the district attorney's office. She was only 25 years old. I met her back then. She was very, very young, very smart. And she's the chief counsel for the Border Prosecution Unit. Earlier today, Mr. Sines talked to you about the different units that the district attorney has. She heads the Border Prosecution Unit. But today she's going to talk to you about grand jury. What is a grand jury? What is the difference between a grand jury and a petite jury? A little bit of that was mentioned to you by the district attorney, Louis Sines, and she's going to explain to you in more detail the important role of a grand jury. So without further ado, I'm going to let Ms. Pattillo take lead in her presentation. Thank you.
Thank you, Professor Garza. I am going to take my mask off. We were all 6 feet apart right now in the room. I know that this is a new thing of virtual learning. I usually give this lecture live, but I can't really talk very well without with the mask on. Like Professor Garza said, I am going to talk to you about what the grand jury is. And there's going to be a PowerPoint provided to you, and it has a lot of these definitions on it. And if you have any questions, you can email Professor Garza, and she can direct it to me or answer it herself because she's got a lot of experience also. Our first slide is, what is the grand jury? Now, the grand jury is a group of 12 citizens from the community that determine whether probable cause exists to move forward with the felony criminal charge or an indictment against the accused. Now, there's a couple of definitions I would like to go over out of that slide that are italicized for you. First is the definition of probable cause. Probable cause is defined as facts and circumstances that would lead any reasonable individual to conclude a crime was committed. Probable cause may not be based on assumptions or intuition. Basically, an example of probable cause is you're driving down the roadway and an officer sees you speeding and he pulls you over, and the driver of the car has been drinking and they had probable cause to pull the car over, and then the smell of alcohol, bloodshot eyes, slurred speech, walking funny, those are all issues that, or indicators that this person's been drinking, and then they caught them behind the wheel while driving. Now, when it says it cannot be based on assumptions or intuition, that means basically that, say that the car is driving, they're not doing anything wrong, but they're near a bunch of bars in the area. Well, the officer can't just pull them over and say, hey, you've been near bars, so therefore you've been drinking and driving. So probable cause isn't huge standard, but it is not based on intuition or assumption. Now, a felony in the state of Texas is defined as a crime that is punishable by confinement in a state jail facility or the Texas Department of Criminal Justice, which is technically prison. The Texas legislature determines the felony classification and codifies the crimes in the Texas Penal Code. An indictment is the charging instrument which lays out the elements of the offense committed and gives notice to the defendant what actions he or she is being charged with committing. Now, I'm using the term felony. There's felonies in the state of Texas and there's misdemeanors in the state of Texas. Felonies are the greater crimes, misdemeanors are the lesser crimes. Now, in a misdemeanor, the charging instrument is the complaint or information, and in felony, the charging instrument is the indictment. Now, I've given you examples of both of those on here. And a misdemeanor, you serve your time on probation, deferred adjudication, or in the county jail. And Class B is punishable up to 6 months in the county jail, and a Class A is up to a year in the county jail. And in a felony, It just depends what degree. A first degree is 5 years to 99 years. A second degree is 2 to 20 years. A third degree is punishable by 2 to 10 years. And a state jail is punishable by 6 months to 2 years in a state jail facility. And all of those face up to a $10,000 fine. And in the misdemeanors, a Class B misdemeanor is a $2,000 fine. And a Class A misdemeanor is up to a $4,000 fine. And again, I gave you examples of what a complainant information is and what an indictment looks like. Now, there's the first step of the grand jury is selecting the grand jury. Now, who is summoned? The district judge shall direct 20 to 125 prospective grand jurors to be selected and summoned with return on summons in the same manner as for the selection of summons of panels for trial of civil or criminal cases in the district court. Now, that means that it's basically, if you've ever gotten a notification in the mail, hey, you need to report to the courthouse to serve jury duty, it's out of the same pool as that, and then the judge sits up there and selects 12 people from the community that are qualified. Now, the qualifications to be a grand juror are: you have to be at least 18 years of age, a citizen of the United States, a resident of the state and county in which the person is to serve, qualified to vote in the county in which the person is to serve, is of sound mind and good moral character, is able to read and write, has not been convicted of a misdemeanor theft or a felony, is not under indictment or other legal accusation for misdemeanor theft or felony, not related to other members of the grand jury panel, has not served on the grand jury in the past year, and is not a complainant in a crime. Now, what a complainant in a crime means is if someone's house gets burglarized and they're the victim of that burglary, they can't serve on the grand jury because they might face at that time a huge bias towards crime, and they might not be fair and impartial, which is which is like a main unsaid qualification of a juror needs to be. Now, there's excuses for it. And a person that's over 70 years of age can be excused. A person responsible for the care of a child younger than 18 years can be excused. A student of a public or private secondary school. A person enrolled in an actual attendance at an institution of higher education. And any other person that the court determines has a reasonable excuse from service. So basically what happens is that around 125 people go into a courtroom. And in Cameron County, it's the 107th or the 103rd District Courts. And they sit there. And the judge does a voir dire on them. And so in that voir dire, she makes sure that all of these people meet these qualifications. Now, for example, if they've been... And we do run criminal background checks on them before, but sometimes things aren't reported to us properly. So, for example, they will ask, are you a citizen of the United States? If someone raises their hand and says, no, I'm a resident of Mexico, they're automatically excluded from the grand jury. So it's more of the first 12 people that fit all of these qualifications get picked to be on the grand jury. Now, once they're picked on the grand jury, they are impaneled, which is a swearing in that they will uphold the laws of the state of Texas. And then they are put, and actually this room I'm sitting in is called our grand jury room in the district attorney's office. And they come on non-COVID times, they come in and there's a rectangular table and they all sit around and the prosecutor stands up and presents cases to them. Now, who is present in the grand jury? It's the attorneys for the state, the district attorney or the assistant district attorneys present the cases to the grand jurors. So where I'm sitting, we would normally have 2 or 3 boxes of files, and I will pull them out and we read a small probable cause statement of what happened in the crime. The grand jury bailiff, which is an investigator with the district attorney's office that helps facilitate the grand jury, and he calls and reminds them to be there and organizes the files as they are presented. And obviously the grand jurors, a panel that decides the probable cause to exist to proceed with the charge. Now, does the defendant have the right to be in here? No. The defendant can only testify to the grand jurors with the express permission from the state's attorney. Does the defendant have the right for the defense attorney to be present? The answer to that is also no. If the defendant does testify in front of the grand jury, the defendant does not have to have the right to a lawyer. However, the lawyer can sit outside the room and the defendant can leave and ask him questions. Now, y'all might be asking, why? Why is this? That's horrible. Like, the defendant should be able to have his attorney. Well, the proceedings in here are totally secret. The grand jurors are sworn to secrecy. We can't talk about it as the state's attorneys. The investigator can't talk about it. It is a secret proceeding so that there is no leak out into the community what was said in this room. And it makes the grand jury, it holds the sanctity of the grand jury together. And the grand jurors can feel secure in their jobs as the grand jurors and feel like people aren't going to be judging them for their decisions. Now, the structure of the grand jury is there's 12 members. There's one foreperson, one alternate foreperson, and then the secretary. Now, when you look at the example of the indictment that I put on here, the person that signs the indictment is going to say the foreman of the grand jury. So once the jurors have decided that probable cause does exist to proceed with the charge, then the foreman of the grand jury signs the indictment, and that's when it becomes an official indictment that gets filed over at the district clerk's office, then sets off the proceeding of people going to court. Now, we have to, not every person can be here every day, so we also have an alternate foreperson in case that person cannot make it one day. And then there's a secretary. The secretary, the grand jury still, we record every case that gets indicted into a big book, and the book has a registry, and the secretary puts whether it got true billed or no billed or tabled. We also have 2 alternates, and they only get called into service if one of the members becomes totally disabled. Now, God willing, things happen. A grand juror might have to have major surgery. Unfortunately, sometimes they might pass away. Well, we have 2 alternates that get called for that. And the grand jurors, they actually meet in 6-month terms. So they're serving for 6 months at a time. Now, the actual proceedings, again, they're totally secret. And then the deliberations are super duper secret. Like, not even the state's attorneys or the investigator are allowed to sit in here. We don't know what is discussed. We don't ask what is discussed. It is amongst the grand jurors. And then they tell us whether they have true billed or no billed our items. Now, in order to get a true bill, 9 out of the 12 grand jurors must vote for the true bill. So 9 out of the 12. That being said, if for some reason all 12 jurors can't be here, we can proceed with 9 grand jurors sitting here. All 12 do not have to be present. As long as there are 9 and all 9 vote for the true bill, then we're good on the indictment. Now, here's some definitions. Again, they were italicized in the previous slide. True bill. True bill is when the grand jury finds that there isn't a probable cause to go forward with the indictment. A no bill is the grand jury finds that there's no probable cause and the case is not indicted. Note, technically the district attorney's office can present a case as many times as they want to the grand jury. So a no bill does not equal a not guilty, as in like a trial. A no bill just says, right now, we don't think that there's enough evidence to go forward with the charge, or that y'all have enough. So what a lot of times a no bill does is we'll kick it back to the investigating agency and we'll say, hey, they said that they don't have enough yet, but it does not kill the case. Other powers that the grand jury has is grand jury subpoenas, and they can bring witnesses in to testify. Now, a grand jury subpoena is, for example, there is a murder, someone gets shot and they survive in the hospital for 2 weeks. Well, part of our investigation is we want to look at what the hospital records were, if there were any statements made by the victim, if there were, what the course of treatment was. What we do is we issue what we call a grand jury subpoena, and we can get those medical records without a warrant, without anything. We can get it through the grand jury. Now, they can also tell us, hey, we're going to table this case, and we want you to bring some witnesses in to testify. And at that point, the witnesses come in and testify, and there is now a court reporter, and their testimony is recorded for the defense to see later on, to see what witnesses are saying. Now, As Professor Garza also said, I'm here to talk about the difference between the grand jury and the petit jury or petit jury. Now, the definitions for this one is there's a veneer panel, which a veneer panel is a group of people summoned to potentially serve on a jury. Now, that exists both with the grand jury and with the petit jury. A petit jury is a group of 12 people in a felony or 6 people in a misdemeanor to determine the guilt or innocence on a charge. Now, on that, the petit jury is when what you see on TV, when the lawyers there's a defense attorney in there, there's a prosecutor, and they're arguing their case. There's the opening statements, the closing arguments, all of that. That's when the defense gets to come in and present their side. And the burden of proof in a petit jury is going to have to find in a criminal case is beyond a reasonable doubt. Now, in the state of Texas, there is no definition for beyond a reasonable doubt, so that is what they're able to just use their common sense and determine whether the state has proved the case or not. And in that one, the burden's totally on the state. The defense does not have to do anything. Now, another definition that I'm going to go through is voir dire. And in other states, it's voir dire. Texas just pronounces it how it looks. In plain English, it's actually a French term. And then this is when each side, the prosecution and the defense, get to talk to the jurors to decide who they would like to sit on a jury. Now, in the voir dire, you're trying to get a fair and impartial jury. And going back to like the burglary example, if your house was burglarized a month before you're about to sit on a burglary trial, the prosecution probably doesn't mean, or defense does not want you, because then you're coming in with a bias, a preconceived notion, and it's not fair. It's not fair to the defendant to have a person sitting on the panel that has a thing for all burglars, that they're all guilty. I got my house broken into. It's awful. I'm going to find them guilty no matter what. We need fair and impartial jurors so that we can get a verdict that is fair to the state and to the defense. Now, the differences between the two, the petit jury and the grand jury. Petit juries are selected through a voir dire process, whereas only the state is present during the selection of the grand jurors. Now, technically asking the jurors questions on when the judge asks the grand jurors questions, it is a technical voir dire, but in the petit jury, both sides ask the questions, not just the state. Petit or petit juries are tasked with determining whether the case is proved beyond a reasonable doubt, whereas the grand juries only determine probable cause. Petit or petit juries always hear live testimonies from the witness stand, whereas the grand juries rarely hear live testimony. On a petit or petite jury, the verdict must be unanimous, whereas on the grand jury, it has to only be 9 out of the 12. Now, again, this concludes my presentation on a grand jury. If you have any questions or any concerns, if you'll please send Professor Garza an email, and I will try to address it to the best of my abilities. Thank you for listening.